One of the biggest scandals that rocked Facebook was how it mishandled user information and got fined £648 million. In this video, we will explain how Facebook shared users' information with Cambridge Analytica, a data analytics firm used by the Trump campaign, without their consent, and how it violated the EU's General Data Protection Regulation. Cambridge Analytica was a British company that claimed to use data analysis and behavioral science to influence people's opinions and behavior. It worked for political parties and campaigns around the world, including Donald Trump's presidential bid in 2016. But how did Cambridge Analytica get access to Facebook users' data? It all started with a personality quiz app called This Is Your Digital Life, created by a researcher named Alexander Kogan. The app asked users to answer questions about themselves and their preferences, and also requested permission to access their Facebook profile information, such as name, age, gender, location, likes, and friends. About 270,000 people downloaded the app and agreed to share their data. But what they didn't know was that the app also collected data from their Facebook friends who had not given consent. This way, Kogan was able to harvest personal information from millions of US Facebook accounts and sold it to Cambridge Analytica for $800,000. Cambridge Analytica then used this data to create psychological profiles of Facebook users and target them with personalized political ads based on their preferences, fears, and values. For example, some users were shown ads that portrayed Hillary Clinton as corrupt or untrustworthy, while others were shown ads that praised Trump's policies or achievements. This was a massive breach of privacy and trust, as Facebook users were not aware that their data was being used for political purposes without their consent. Moreover, this violated the EU's General Data Protection Regulation, GDPR, which came into force in May 2018 and requires companies to obtain explicit consent from users before processing their personal data. The GDPR also gives users the right to access, correct, delete, or transfer their data, and imposes hefty fines for companies that fail to comply. The maximum fine under the GDPR is 4% of a company's annual global turnover, or €20 million, £17.5 million, whichever is higher. Facebook faced multiple investigations and lawsuits over the Cambridge Analytica scandal, both in the US and in Europe. In 2019, Facebook agreed to pay $5 billion, £3.6 billion, to settle a Federal Trade Commission probe into its privacy practices. This was the largest fine ever imposed on a company for violating consumers' privacy rights. In 2020, Facebook was sued by a group of nearly 1 million users in England and Wales for misuse of information. The group accused Facebook of allowing third parties, including Cambridge Analytica, to access their personal data without their consent. The proposed settlement for this case is $725 million, £600 million, which is the largest in a U.S. data privacy class action. Facebook has apologized for its role in the scandal and said it has revamped its approach to privacy over the past 3 years. It has also banned several apps and developers that abused its platform and restricted the amount of data that apps can access from users. However, many critics argue that Facebook's fines are too low compared to its annual revenue of $86 billion, £63 billion, in 2020. They also question whether Facebook has done enough to prevent similar abuses in the future and protect its users' data from exploitation. One of the biggest scandals that rocked Facebook in recent years was its mishandling of user information and the resulting fines and sanctions from various authorities. In this section, we will focus on how Facebook was fined by the Irish Data Protection Commission for more than €746 million, £648 million, and ordered to suspend data transfers to the US as a result of a legal challenge brought by an Austrian privacy campaigner, Max Schrems. The Irish Data Protection Commission, DPC, is the lead regulator for Facebook and other tech giants in the European Union, since their regional headquarters are based in Ireland. The DPC has the power to impose fines of up to 4% of a company's global annual turnover for violating the General Data Protection Regulation, GDPR, which is the EU's data protection law. The DPC has been investigating Facebook for several issues related to its data practices, such as data breaches, transparency, children's data, and data transfers. In 2021 and 2022, the DPC issued 4 fines against Facebook and its parent company Meta, totaling almost €1 billion. The first fine was €225 million, £193 million, in September 2021, for failing to provide adequate information to users about how their personal data is processed and transferred across borders. This fine was based on a complaint filed by Max Schrems in 2013, after he learned that Facebook was sharing his data with U.S. intelligence agencies through a program called PRISM. The second fine was €17 million, £14.6 million, in March 2022, for breaching EU data privacy laws by not having appropriate technical and organizational measures in place to prevent 12 data breaches that occurred between June and December 2018. These breaches exposed the personal details of millions of users, such as phone numbers, email addresses, and dates of birth. The third fine was €265 million, £228 million, in November 2022, for another data breach that saw the personal details of hundreds of millions of Facebook users published online on a hacking forum. The DPC found that Meta was in breach of Article 25 of GDPR, which requires data controllers to implement data protection by design and by default. The fourth and largest fine was €239 million, £206 million, in December 2022, for violating Article 46 of GDPR, which regulates data transfers to third countries that do not have adequate levels of data protection. The DPC ordered Meta to suspend all data transfers from the EU to the US within 3 months or face further sanctions. This fine was also based on a complaint by Max Schrems, who challenged the validity of Facebook's use of standard contractual clauses, SCCs, as a legal basis for transferring data to the US. Max Schrems is an Austrian lawyer and activist who has been campaigning for better data protection rights for EU citizens since 2011. He is the founder of NOIB, None of Your Business, a non-profit organization that uses strategic litigation to enforce privacy laws. He has filed several lawsuits against Facebook and other tech companies over their data practices, and has won landmark cases at the European Court of Justice that invalidated 2 mechanisms for data transfers between the EU and the US: the Safe Harbor Agreement in 2015 and the Privacy Shield Framework in 2020. Schrems argued that these mechanisms did not provide adequate safeguards for EU citizens' data against US surveillance laws, such as Section 702 of the Foreign Intelligence Surveillance Act, FISA, and Executive Order 12333. He also claimed that SCCs were not sufficient to ensure compliance with GDPR, since they do not bind US authorities or courts, and do not offer effective remedies for EU data subjects. The DPC agreed with Schrems' arguments and found that Meta had not demonstrated that it had conducted a proper assessment of the risks involved in transferring data to the US, or that it had applied additional safeguards or measures to protect users' rights. The DPC also noted that Meta had not informed users about the possibility of their data being accessed by US authorities or courts, or about their options to object or withdraw consent. The DPC's decision to suspend data transfers from the EU to the US was a major blow to Meta's business model, which relies on collecting and processing large amounts of user data across its platforms. Meta appealed the decision at the Irish High Court, arguing that it was disproportionate, unfair, and unlawful. Meta also said that it would comply with GDPR and cooperate with regulators to find a solution that respects users' privacy and enables innovation. The Irish High Court is expected to hear Meta's appeal in early 2023. The outcome of this case could have significant implications for other tech companies that transfer data from the EU to the US or other countries with different data protection standards. It could also affect the negotiations between the EU and the US on a new framework for transatlantic data flows, which are ongoing since the invalidation of Privacy Shield. In summary, Facebook was fined by the Irish Data Protection Commission for more than €746 million, £648 million, and ordered to suspend data transfers to the US as a result of a legal challenge brought by an Austrian privacy campaigner, Max Schrems. This was one of the biggest sanctions ever imposed on a tech company for violating GDPR, and it showed how serious the EU is about protecting its citizens' data rights. In July 2019, Facebook agreed to pay a record-breaking $5 billion penalty to the Federal Trade Commission, FTC, to settle the charges that it deceived users about their ability to control the privacy of their personal information. This was the largest civil penalty ever imposed on a company for violating consumers' privacy, and one of the largest penalties assessed by the EU government for a violation of any kind. The settlement was the result of a sweeping investigation by regulators into how Facebook lost control over massive troves of personal data and mishandled its communications with users. The FTC sued Facebook in 2012 for making misleading promises about the extent to which consumers could keep their personal information private. For example, Facebook told users they could select settings to make information available just to friends. But despite that promise, Facebook allowed apps used by those friends to access consumers' information, a decision that put money in Facebook's pocket. The 2012 FTC order put penalties in place if Facebook made misleading statements in the future about consumers' control over the privacy of their personal information. According to the FTC, that's just what happened. Facebook violated the order by again giving companies access to information that consumers said they didn't want to share. The FTC also alleges Facebook made other misleading statements about how it used facial recognition, consumer cell phone numbers, and other personal data. The settlement required Facebook to conduct a massive overhaul of its consumer privacy practices. The settlement also made major changes to Facebook's operations, and CEO Mark Zuckerberg no longer had sole control over privacy. The order established a new era of privacy transparency at Facebook and at WhatsApp and Instagram, which Facebook owns. It created an independent committee of Facebook's board of directors to oversee privacy decisions and required an independent third-party assessor to evaluate the effectiveness of Facebook's privacy program. The order also required Mark Zuckerberg and designated compliance officers to certify quarterly and annually that Facebook is complying with the order's requirements. Any false certification would subject them to individual civil and criminal penalties. Additionally, the order prohibited Facebook from using phone numbers obtained for security purposes for advertising, required it to provide clear and conspicuous notice of its use of facial recognition technology, and mandated that it encrypt users' passwords and regularly scan for password leaks. The settlement was a historic moment for consumer privacy protection in the EU. It sent a clear message to Facebook and other companies that they must respect their users' privacy choices and be accountable for their actions. It also gave users more power and control over how their personal information is collected, used, and shared by Facebook.